like to begin by thanking our very, very generous and supportive co-hosts. Thank you very much to Finland, Germany, the United Kingdom, Norway, Austria, and the government of the Netherlands. We were recently in Nigeria last week, Bettina and I, where we conduct capacity building for Nigerian civil and military prosecutors. And during one of our sessions, one of the participants came to me and said, "Oh, I see the Bemba judgment is out." And his comment was, "That's quicker than normal." And I sort of said, "I wish you were coming to our side event because we're talking about exactly this, the time it takes for these decisions." And I raise it only to point out that the issues we're discussing today are of great significance to everybody, especially in places like Nigeria, which is a preliminary examination country. So I'm very much looking forward to the panelists and their comments and thoughts. And I will begin by introducing Ambassador Kersten Wenaweser, who has very graciously chosen to join us today. Thank you.
Well, thank you. Thank you so much, Angela, and thanks to Wayamo and the co-sponsors of this event. I was invited to just offer a couple of opening remarks. I very much look forward to hearing from the panel. But I think it's very timely to in fact do this at this ASP that is a bit dominated by discussions on review or reform, depending on who you are, and that will determine your terminology. But there is a strong sense that we need changes, and we need to make the court a better performing body. This particular discussion, in my view, also shows that there is a lot that the court can just do on its own, and I think it's important to acknowledge that the court has responded to this particular challenge in recent months, and I'm sure we will hear from the panelists on that. I think the length of the proceedings has been an issue that has been on the minds of many of us for many years. Many of us who have followed the court's work for many years, and I have to admit that me personally, sometimes when receiving one of the judgments in the inbox, that my first reaction was, "What took you so long?" And that is not to be flippant about this, but I think it's important to acknowledge that this is a question that is on the minds of many. So it's in the interest of the court, and it's the interest of all of us to address this in a very professional manner. And I'm sure the discussion that we will have will help us a lot in this respect. This really has two aspects. We'd like to think a lot about the use of our resources, the efficiency of the proceedings, and that is certainly a very important aspect. Also, our understanding and the transparency in the proceedings of the court. But of course, a very big aspect is also the right of the defendant that can be impacted on pretty severely depending on the length of the proceedings. A separate discussion, and the one I perhaps look forward to the most, is on preliminary examinations, which is more of a policy discussion, but nonetheless perhaps the one of the highest possible importance. So, enough from me. I very much look forward. Thanks for including me, and I look forward to hearing the panel. Thank you.
Well, thank you very much, Ambassador Wenaweser. Thank you to everyone for coming to our event on the timing and duration of ICC decision making. And thank you as well to the Wayamo team, to Angela, Elise, Nazaline, Bettina, and to all of our sponsors for making this happen. I'm Mark Kersten. I'm a senior consultant at the Wayamo Foundation. To begin, I thought I would just list some dates. The 1st of May 2003, quote unquote, sometime in 2007. 30th of October 2017, 3rd of November 2017, 20th of November 2017, 12th of April 2019, 17th of September 2019, and the 4th to the 6th of December 2019. Some of you will know what those dates relate to. They relate to decisions that the ICC and its various organs have taken in relation to the situation in Afghanistan. And the question is whether those dates and the time between them make sense. Do they hold any kind of strategic logic? Is there a logical premise to them? Do they have strategic coherence? Does the timing of events regarding ICC decision making, be it by the chambers, by prosecutors, by the registry, make sense? If not, if there is no strategic coherence to them, what does this mean for the people that engage with the International Criminal Court, for victims and survivors, for states, for defense counsel, for civil society? And to delve into these questions and what can be done about the duration and timing and improve the duration and timing of ICC decision making, we have a wonderful panel. First, I have to regretfully inform everyone that unfortunately Dapo Akande could not make it. However, that means that we get to hear even more from our esteemed panelists. First of all, we have Liz Evenson, the Associate Director of the International Justice Program at Human Rights Watch. Then we have Lorraine Smith Van Lin, who's a post-conflict justice advisor at REDRESS, and Shehzad Charania, the Director of the UK Attorney General's Office and the International Law Advisor to the Prime Minister's Office in London. And so I'd like to start with you, Lorraine. What are some of the reasons given and concerns expressed over the duration of decision-making at the International Criminal Court, perhaps with respect to the institutional or structural elements of what's going on? And you guys are good. Yeah.
Thanks very much, Mark, and to the Wayamo Foundation for this invitation. I think it's a really important discussion at this time. And I don't want to assume that everyone has some idea of the ongoing discussion about the planned review. But in the interest of time, I am going to make that assumption, only to say that certainly as one of the organizations following this, but certainly not as closely as Human Rights Watch, REDRESS, which is an organization that works on behalf of victims and, seeks to amplify the voice of victims in these kinds of proceedings, takes very seriously what is happening and what is planned in relation to this review. So to answer Mark's question very briefly, what essentially setting the stage for this process of review, I'd like to invite you to step back with me in order for us to look ahead. Because before I joined REDRESS, I used to be at the International Bar Association as one of the persons monitoring the International Criminal Court. And it's very interesting to see how far we've come, 5, 6, 7 years, since I left the IBA, looking at a review process that effectively is, looking at a number of the issues that we considered then. And what were some of those issues? The timing and duration of proceedings, the impact of the participation of victims on the court, the nature and the efficiency of investigations by the Office of the Prosecutor. I looked at it then from the angle of how this impacted the fairness of proceedings. So I focused very much on the issues to do with the defense. It's quite interesting that when I stepped across to REDRESS and started looking at it from the angle of victims, I found that the concerns are very, very much the same. Victims and affected communities are very concerned about the length of time that it takes to get ICC decisions out. And why is that so? It is not that there isn't an understanding of the complexity of proceedings at the international level. There isn't a lack of understanding, I would say, about the fact that the ICC is a novel court and the participation of victims, among other things, is actually quite novel. And when I say novel, I am referring to the fact that the ICC has set standards. It's a first in relation to certain specific things, including the participation of victims, including the role that its pretrial chamber plays, which is very different from the role played at the ad hoc tribunals. These are novel things, and I believe that there is some level of understanding there. It is also understood that the ICC is far from the communities that it serves, and it is dealing with, in many situations, ongoing conflict. So there is that understanding. The broader question, though, is that when we went to Kampala in 2010 at the review conference, many around the table said, well, the ICC is still in its infancy. At this stage, when in 2018, we have now celebrated, I think, 20 years of the Rome Statute, the question is, what do you do with a young adult? And so we're going to have to now take very serious looks at exactly what the issue is. And I'm happy to see Ben Gumpert at the table and hope you will have the chance to intervene given your very detailed blog posting on this issue. So I'll flag a couple of issues that we've noticed, and I don't want stop me, Mark, when I go over. Some of the issues were raised in previous reports, and I want to put them on the table. One was a report that was prepared by an expert group, which included persons like Dr. Gwenelle Metro in 2014, Judge Shireen Fisher, Hakam Freeman of blessed memory, that looked at a number of the concerns that were plaguing the court at that time. The IBA report that I referred to on efficiency before the court was written in 2011. Another report was written by the War Crimes Research Office on expediting proceedings at the ICC. And what were some of the issues we found? The first, structural issues. The structural issues included the participation of victims, the role and function of the pretrial division, and effectively the challenges that tend to come from the fact that the judges were coming from different legal backgrounds. One of the issues that we also noticed was the challenges in relation to procedural issues, for example, in relation to the appeals processes. Significant delays seen there. And another interesting one, which came also based on consultations with a number of stakeholders within and outside of the court, was what appeared to be an absence of collegiality at the level of the bench, but it was also said to be elsewhere. And this is something that I hope that we'll have a chance to discuss as well during this event, Mark. I'm going to pause there to give others a chance.
Thank you very much, Lorraine. Over to you, Liz. Human Rights Watch has done a lot of work around preliminary examinations, and as Ambassador Wenaweser said, one of the issues is duration. So could you speak to us about some of the concerns that are raised with respect to timing and duration of preliminary examinations?
Thanks, Mark, and it's great to have so many in the room and to be in such good company up here. So I think that when I hear concerns raised about the length of preliminary examinations, it's most often a concern of are they taking too long? Not exclusively, because I also remember when the Kenya situation was opened, there was some discussion whether that was too preemptive. Had not enough time been given to national authorities to carry out their responsibilities on justice. I think looking back, I'm not sure that critique stands up. But just to say that I think there's a sort of a damned if you do, damned if you don't approach to the length of preliminary examinations. But the focus more recently has been on, are they too long? And that's led to some questions as to whether there should be timelines imposed on the length of preliminary examinations. What I want to suggest is it's not that length isn't an issue. Of course it's an issue. Ambassador Wenaweser spoke to that. Time matters. It matters to victims. It matters to defendants or potential defendants. It matters to evidence collection opportunities. But I think maybe what's more relevant or a better frame is what are the goals of preliminary examinations, and are the processes in place well adapted to those goals? And time is, I think, not a great proxy for drilling down into that central question. The focus of our work has really been on, in fact, an opportunity that preliminary examinations present that may, in fact, require some time, or at least not be amenable to an arbitrary sense of how much time. And that has been the opportunity that's presented by the engagement between the Office of the Prosecutor and national authorities to encourage and catalyze credible national proceedings. This is an opportunity in preliminary examinations that isn't going to be possible in all preliminary examinations. In fact, actually, it probably has a relatively limited application to some certain situations where there is some prospect of, with engagement and with time, bringing about credible national proceedings. And I think the Office of the Prosecutor has been quite clear on that this isn't something that they are trying to do in all preliminary examinations. But nonetheless, it does present a real opportunity. We've seen perhaps the most successful example of this is in Guinea, where a preliminary examination was opened just a few days after a massacre that took place in 2009. Within a few months of the preliminary examination, a national panel of investigating judges had been convened. Then there was a lot of up and down and very halting progress in national investigations, but they were eventually completed in 2017. A steering committee was set up to try to bring together the elements for a trial, and just recently, finally, a date for that trial was announced. It shows, I think, that when I talk about successes, we're still talking about a very long time and we're not at a trial. But the Office of the Prosecutor's engagement has actually been a real factor in these steps, alongside with many other partners and the commitment of national authorities. So I don't want to overstate the opportunity, and I think it has to be very clear that this is secondary to the main goal of arriving at a decision as to whether an ICC investigation is warranted. But the opportunity is there, and I would say it's not optional. I don't think that we can get caught up on whether the term positive complementarity exists in the Rome Statute. But when we're talking about very difficult landscape on justice, limited capacity at the ICC, limited willingness on the part of states parties to provide the resources, also the cooperation that the court needs, I just don't think we can afford to be cavalier about any opportunities that exist to try to bring about credible national proceedings. And the amount of engagement and time that it could take to have a process that brings about a credible, and again, it has to be a credible national process, is something that I think would be undercut by having a very one-size-fits-all or arbitrary deadlines about the length of preliminary examinations.
Thanks very much. Liz, Liz has mentioned that time or duration might not be a good measure of success of preliminary examinations, but it certainly has been put forward as something that judicial proceedings and decisions have to be measured by. Can you speak to us about that?
Yeah. Thank you, Mark, and thank you from me too to the Wayamo Foundation for inviting me to speak and to enable me to escape the horrors of Brexit and elections for a couple of days. I think we've heard from Lorraine about a number of factors which affect decision-making and the speed and duration at the ICC. And I just wanted to step back a bit because Lorraine has focused on the court, and I think that's where the focus has been for much of the recent past. But I think it's also important to look at the role of states here too. And in that vein, I think there are a couple of things to look at specifically. First of all, state cooperation. Now, there have been more than 20 odd findings of non-cooperation by the court against states, yet when these findings have been referred to the UN Security Council or the ASP, they haven't even made it onto the agenda of the meeting. We had the spectacle of Russia and China blocking even a mention, even a response to the president. Okay, sorry. At the UN Security Council, we had Russia and China who wouldn't even allow the Security Council to acknowledge a letter from the president of the court communicating a non-cooperation decision in relation to President Bashir. And we saw in the Kenyatta case that even after the prosecutor had decided that she had insufficient evidence to proceed, the proceedings continued for over a year while the prosecutorial team attempted to elicit information and cooperation. So there's a clear and central issue around state cooperation, I think, which affects the time it takes for trials. The second aspect, I think, where the role of states is critical is as secondary legislators, as the people who have to adopt changes to the rules of procedure and evidence. And we have seen in the past where judges have put forward amendments for states to approve, and those amendments have been with a view to speeding up proceedings, that the discussions have become very political and states have refused to adopt those amendments. I think of back in 2015 or so, when the judges asked states to approve amendments dealing with translation of prosecution witness statements. Now, there'd been a couple of cases, Banda and Gerbo, where that process had taken over 18 months. And the judge's aim was to reduce that to about 3 or 4, but states refused to adopt those amendments. And in fact, it was just 1 or 2 states that held out. So those are, I think, 2 specific reasons why states also need to think about their own role in the duration of proceedings. But I think my final point does go back to the role of judges and the speed of their own decision making. And I think the recent pronouncement that they will self-impose deadlines is both radical, in the sense that it's the first international criminal court to do such a thing, but also ambitious. These are not backstop timelines. 10 months for a trial judgment, 4 months to decide on a request from the prosecutor to open an authorization. These are ambitious and have to be welcomed. But if we take a step back as to whether, Liz talked about the arbitrariness of deadlines for preliminary examinations. I think in this case they're absolutely necessary. It shouldn't be the case that similar cases take wildly different time scales to complete. So, for example, at the ICC, we saw the difference in how the Ruto chamber proceeded and the Kenyatta chamber, the difference in time. What was the real difference? Well, perhaps one might point to the fact that there was a less experienced presiding judge in the Kenyatta case than in the Ruto case. We also saw it at the ICTY, of course, in the cases of Perlich and Popovic, where with Perlich it took over 9 years to try 6 defendants, and in Popovic it took less than 4 to try 7. And there was nothing else very different about these cases other than the judges sitting on them. The facts were broadly the same. So I think judges having these 10-month deadlines for rendering trial judgments is only one part of the judicial process, but they're nevertheless extremely welcome and hopefully will provide greater impetus for efficiency across the rest of proceedings.
Sticking with that theme, Shehzad, how do you think, or how would judicial deadlines affect the credibility and the legitimacy of the institution in the eyes of the states? And you spoke a little bit that states also have to take responsibility. How can they also take responsibility in this respect?
So I think when the court, and in particular the judiciary, is under such intense scrutiny as it currently is at this ASP and in the recent past, having these deadlines can only help relations with states. And I think it's of credit to the judges that they didn't hide behind a kind of false cloak of independence not to take this step, which I think would have been wrong. But there has been discussion in the past as to whether the court should have deadlines. And as I say, in my view, it was absolutely right that they took this step to self-impose deadlines. And I think that's for kind of three reasons. First, there are already deadlines that exist in the Rome Statute, in the rules of procedure. For example, a 60-day deadline to render a confirmation decision. There are various other deadlines for prosecutors and defense to lodge filings. So it's not an alien concept to introduce deadlines for decisions. Second, in 2014, under a Swiss initiative, the court embarked on a project to establish performance indicators. Now, these are embedded in the court's strategic plan, and we've seen the latest report on performance indicators issue just this week. So where the court was devising targets against which it would measure itself, it's only logical that it should then extend those measurements to timings of court decisions, so that we don't see another 15-month wait for the Afghanistan preliminary examination decision, which would now, under these new guidelines, have to be rendered within 4 months. And that goes back to my point about these timelines being extremely ambitious as well as welcome. And the final point, I think, again, to show that this is a welcome step, but it's a logical progression. At the ICTY, they submitted in their completion strategy to the Security Council timeframes for particular decisions based on number of defendants, the complexity of the crimes, and set out how long they thought each case would take. So again, there is not a direct precedent for this, but a way in which people have thought about how long it should take for individual cases to be completed. And so again, it's a logical step for the ICC now to establish deadlines. And again, as I said at the beginning, something that should be welcomed.
Thanks very much, Shehzad. Lorraine, you spoke about a little bit about defense. You spoke quite a bit about victims. Your work engages them. How do you think issues of timing and potential deadlines on judicial decision making would affect victims and their sense of the credibility and legitimacy of the court?
It is a legitimacy issue for victims, and I'm going to start at the end a little bit and then work my way back. So, for example, in relation to the issue of reparations, we understand that the court has, that reparations at this stage, the court has relatively little understanding and experience in doing reparations proceedings, as well as, and this was admitted by a judge yesterday, relatively little experience. I don't know of many of the judges who are actually sitting on reparations proceedings who are experts in mass claims cases. So what we have is a situation where you could have very prolonged proceedings. In one particular case, for example, the Lubanga case, we had an impasse that lasted for months, I think maybe 15 or so months, between the trial chamber and the trust fund for victims based on their differing interpretations of their respective roles. And, you know, essentially what the trial chamber felt was the trust fund not following its instructions. And that impasse continued for months. That has a knock-on effect on victims who are waiting to this day for reparations. So again, the issue of the length of these proceedings and how that translates, if we put it down to basic, essentially we're dealing with victims who are still suffering pending decisions. So it's one thing to talk about this in general terms, but when you bring it down to brass tacks, as the victims in the Bemba case said, essentially they were saying, we have waited for 10 years only to have an adverse outcome, and we are left with nothing. And we were given this sense that it made sense to believe in this process because of the absence of any similar process in the Central African Republic, at least in respect of these victims.